We now have the first of its kind on this topic because we've been holding our breath. It is going to literally start changing everything. Claiming that scraping copyrighted content is fair use has become common for AI developers facing copyright lawsuits. You know, courts are way more, they get vicious. So we've been holding our breaths because there are so many lawsuits generally being filed against AI companies, but also in our little niche of music business, we have lawsuits against Anthropic, Suno, Udio for infringing, allegedly, the copyrights of major record labels. So for example, Anthropic, the claim was that Anthropic, which is similar to like ChatGPT, you would put a little prompt in and it would literally spit out the full lyrics to other people's songs. Comparatively, the claims against Suno, Udio, same thing. You would put in a very general prompt of just like, I need a Christmas song with a female singer with this kind of vibe. And it would spit out like Mariah Carey. So the claims were pretty, yikes. And with enough pressure from these actual lawsuits, Suno and Udio in particular did come back and they go, you know what? We did use your songs, major record labels, in the training of our AI, but we don't think that it's copyright infringement because of fair use. Fair use is an affirmative defense to copyright infringement, meaning if you in fact qualify for fair use, you say it's a get out of jail free card. So for example, one thing might just be this channel. From time to time, I will react to someone else's video. Like, for example, I will react to someone who's having a legal problem and they put a video on YouTube and I will watch it and then give thoughts and commentary and things like that. Under copyright law, well, that's an unauthorized use of someone else's video, right? They didn't necessarily give me permission, but pursuant to fair use, it would be okay because I'm reacting to it, I'm transforming it, I'm giving commentary, criticism, and it's educational. So we now have the first of its kind on this topic because we've been holding our breath. When these courts start coming down with the ruling on whether this is fair use, it is going to literally start changing everything. Because here's the reality. If the courts start coming back and they're like, yeah, it's fair use, meaning the AI companies just go take whatever you want. Songs, videos, books, whatever. Take whatever you want, train your AI. You don't have to pay anybody. No licensing fees, no permission required. And if it is in fact fair use, that's great for AI companies, right? They don't have to ask or pay for anything. But conversely, the claim by the creators of all that stuff that got used is that all of a sudden now we didn't get paid, right? Number one. Two, we think it's copyright infringement because the copyright laws say you don't get to use this stuff unless you get permission. And then number three, basically, this is a total watering down of licensing. Like, what is the point of trying to license anything ever again when an AI company can essentially just go in and be like, we're just going to train our stuff and then it's going to spit out new stuff that was based on your stuff? Whatever. In a summary, that's kind of what's going on. So we do have the first of its kind. This is what's going on. A music business worldwide using copyrighted content to train AI without permission was deemed not to be fair use pursuant to one court. Now, this is in regards to, funny enough, a case involving a legal platform. It's called Thomson Reuters. I've used this platform before for all kinds of things, but like lawyers have platforms that they use. So for example, there's like Westlaw, and Westlaw, which is Thomson Reuters, might give a database and I'm like, hey, I need to look up all the cases on, I don't know, fair use. And I need to find it for my jurisdiction and all this stuff. So I can use these platforms. It pulls all the cases and all the opinions from the judges. And so I can do case law research. Okay, so that's a little bit of what this was. So let's see what happened. So for the first time, a US court ruled on whether using copyrighted material without permission to train AI constitutes fair use. Under copyright law, the news is mostly good for copyright holders. The judge in the case has ruled against the AI company. However, there's a wrinkle. We're going to come back to that. The case in question pitted media news conglomerate Thomson Reuters, which is the owner of a news service. Okay, so the defendant that got sued, Thomson Reuters, okay, sues Ross Intelligence. Ross Intelligence, which is now a defunct service, in 2020, they sued Ross for copyright infringement, alleging that Ross had scraped through Thomson Reuters' law database, which is known as Westlaw, to create its database. Let me put this for you like this. Do you remember when you search on Google, sometimes you'll be like, need to find eyebrow waxing place. And so, the title of the place comes up, and sometimes there'll be a little summary, right? It'll be like, we're the premier eyebrow waxing and we'll make you beautiful within 5 minutes. So they have a little summary. Something similar was happening on the Westlaw platform, okay? And these were called head notes. And so it would basically be a little synopsis from, let's say, the court's order. So the court's order is like 40 pages long, and Westlaw would go in and take a little section from it, and then that would be kind of the little highlighted piece. So it'd be like, hey, like if you're trying to look at this case, this is something that might help you make a decision whether this is the case you really should read, okay? So those head notes were really just from the long form thing from the judge, right? But it was a head note that, basically was used in the population of like case lists, right? That's what was happening. Much like AI companies defending themselves against lawsuits by music companies, Ross Intelligence argued, amongst other things, that its use of the Thomson Reuters copyrighted content, right? So these little headers should be given fair use exception, right? So in the ruling, the judge, and this was for the District of Delaware, guys, this is a federal court, rejected the argument. The judge overturned an earlier order, which was about the same issue, but the judge, this made me laugh. This is what the judge put in his order. He's like, hey, I'm changing my mind. He's like, I literally ordered something totally different. And now I'm changing my mind. He goes, quote, a smart man knows when he's right. A wise man knows when he's wrong. The judge wrote in his new ruling, quote, wisdom does not always find me, so I try to embrace it when it does, even if it comes as late as it did here. I don't know. I appreciated that. So anyway, the judge goes, look, when I initially was considering this on a motion for summary judgment, I looked at these headlines and I'm like, well, you didn't write this. What's the copyright? You didn't write this. This just came from the case. And so can Thomson Reuters really claim that this other company came and ripped them off by stealing their headers? Because they go, well, what this company, Ross, did is they took the headers and they put them into questions. So they literally just like took it, made it as a question, and they built up their database. And they did this after they had tried to license this stuff from Thomson Reuters. Thomson Reuters said, no can do. So then Ross went a different route. So, in any case, this is part of the analysis. So the court just came back and goes, look, in order to get copyright, you need to have the smallest amount of creativity. You have to have some level of your creativity in the thing that is created, but it's really small. And so the court goes, are we really going to give copyright protection for this company just having these headlines for these different cases? Like, what's the creativity there, right? And then the court in this newest order came back and said, no, there is creativity because you have to go through the 40 pages per document, right? And decide what is the thing that you're going to use as the header, right? So the court said, in that case, I'm saying there was creativity here. Those were copyrighted things, right, in the compilation of putting it all together. So, there we go. If you're needing legal help, feel free to reach out to Delgado Entertainment Law, which is my firm. We offer free case evaluations with our case managers. So just meaning you don't have to make any kind of commitment. We'll just see how we can help you. Feel free to call us. You can text, you can email. We look forward to hearing from you. Now, in this article, they make the comparison to these other lawsuits against Anthropic, Suno, and Udio. Let's see what it says. On its face, this looks like really good news, right? Because if there is no fair use, if these courts are going to say, no, you don't get to just go take someone else's stuff and be like, I transformed it, it's fair use. And we'll go through what that analysis is. But obviously, that would be really good for creators, for music owners, right? The fair use defense has been rejected in at least one case now, right? Involving scraping copyrighted content to train AI. Seemingly exactly the same sort of thing that AI developers like Anthropic, Suno, and Udio have been accused of doing. Claiming that scraping copyrighted content is fair use has become common for AI developers facing copyright lawsuits. Okay, and we know that. We kind of went through what those claims were, right? The lyrics issue. Obviously, Suno, Udio, they were both sued last year by Sony, Universal, Warner. The same thing. No, it was fair use. But they obviously admitted. They're like, yeah, we did it. It just was fair use. In light of the Thomson Reuters victory, this is good, but there was a distinction. So the distinction was that in the case with Suno, Udio, Anthropic, those are generative AI platforms. So meaning it's going to take and study from your stuff, and then typically it's going to spit out something new. It's generative. This wasn't generative AI. And so the idea is like, well, is this basically the floodgates are going to be coming down now? And so all the other courts who are hearing these cases right now, perhaps will look to this court and say, well, you did this way, you had this certain analysis, or is this distinction about the generative AI piece going to be enough to just not be persuasive? So is this basically one of a kind, or is this the first that's going to start the domino effect? Okay, so in the factors, right? So the court, in fact, here it is right here. This is the court's order. So the factors for fair use, of which Ross, right? So the defendant who's saying, no, this is fair use. You don't get to sue me. The person who is getting sued, who wants to use this as a defense, has to claim. And so same with Suno, same with Udio. They're the ones that are going to have to prove that, what they've done is fair use. And so there's 4 factors. And factor number 1 and 4 are probably going to be the most important, but let's take a quick peek. All right, so the 4 factors: 1, the use and purpose character, the copyrighted work's nature, how much was used, and then does it affect the market value? So specifically, what is the purpose and character? So meaning, are you making money from this? So if we have like a charity or something who came in and took some copyrighted stuff and they're like, no, we're just trying to educate. Obviously, education is fair use category, but generally speaking, if something is like straight up, hey, no, I'm using my music AI platform to train from other people's songs so I can then go and make money, that weighs not so well for the music AI platforms. And then the 4th factor, which is how does this affect the copyrighted works value in the potential marketplace? If someone is recreating songs that are like legacy acts and this and that are now going to be used in TV and film and all kinds of licensing opportunities because they don't want to go and pay the big bucks, right, for the original songs, they'll just use AI instead. Does this impact the market value of human-made original songs? And the answer is yes. Okay, so anyway, the court looks at this within this case, and the court heavily relied on those 4 factors. All right, so number 1, what was the purpose, the nature of the work, the amounts, and how much was used, the effect on the potential market. Importantly, the Thomson Reuters case, the judge ruled in favor of Thomson Reuters on factors 1 and 4, but against Thomson Reuters on factors 2 and 3. So it really is an analysis. And so if you are considering, this kind of thing, this is why we have to go through and be like, does it make sense? Are you likely to succeed on this kind of affirmative defense? Okay, so more analysis in regards to the different factors. So again, this works in music companies' favors. They can argue that AI tools that create music result in a product that directly competes with music companies whose material was taken, right? So this is the 4th factor. They can also argue that AI developers could have developed their generative engines without infringing copyrights. Guys, the reason why Suno and Udio could win on their fair use argument is because part of the analysis is, well, what was created in the use of the copyrighted stuff? It's not so much that we say, well, they used the songs and they created songs. No. What they're arguing is that they use the songs and they created technology. Now the technology makes songs. Okay, that's like a little byproduct, but no. We are advancing science and technology, and we're basically making the world a better place. That is the purpose of copyright, and that's why we have copyright laws. So if they were to succeed, something along those lines would be the reason why, in my opinion. And it's because they go, if we can prove we transformed the songs because we studied and we created technology and AI, that's how they could succeed on this. Okay, so going back to this though, we do nonetheless have a case now that I think is going to be persuasive. All right, so the judge concluded Thomson Reuters legal database with Westlaw isn't very creative. All right, we talked about that. It's a searchable database of publicly available court documents. This would likely not apply to music, which is seen by the courts as being highly creative. Courts are way more, they get vicious when it comes to these analyses, when it comes to creative stuff. It gets more attenuated if you're someone that's like, no, it's fair use, and you used someone's creative thing, because we want to protect creators, right? Copyright Act, anybody? If you're using someone's song, right now, we're going to give a little bit more weight to some of the factors because of that. So that's why, at least what they're saying here is they're like, not sure that this is really going to apply to the Suno, Udio, Anthropic cases. All right, again, likely won't apply in cases brought by the music companies because in those instances, each work of music has its own copyright. And in this instance, the music companies will likely argue that the AI developers took all of each of the recordings. That's right. All right, if the courts in the music company copyright cases follow this precedent, the issue of fair use will be determined primarily by two questions. Is the AI company's use of the copyrighted works transformative? And does the output lessen the value or compete with the originals? So, I think the argument is it's transformative in that what we're transforming is tech, not new songs. But even in the new songs, quite frankly, they'll be like, so what? It came up with a Christmas hit. Yes, Mariah Carey has 18 of them, but we can come up with one too. So is it transformative? And then is the output competing with the originals? And again, it's just like, what was it? I mean, we were talking about just Deezer, right? The other day, and we're like, just on the Deezer platform, and that's like a baby platform. They're ingesting something like 10,000 AI tracks. Was it daily? So the point just being that the whole is AI in general devaluing, diluting the general marketplace of human-made music? Yes, it is. Okay. But things change, right? There are now AI artists, there are AI creators, there's all of you in the middle who use AI, and then you're also human-made stuff. So can we say, though, that the new Christmas song is making it so that Mariah Carey can't make as much money when it comes time for Christmas? So there are a lot of songs, a lot of alleged infringements, and that's why these cases get really complicated. On the second question, does AI generate music lessen the value of copyrighted human-made music and compete in the same market? Am I look at an open-end shut case from the perspective of right holders? Of course they do. But AI music making tools like Suno and Udio allow people who've never created music, people who would never have signed with a record label, who would never have performed in a live venue, to generate tracks. These companies make money by selling subscriptions to their music making services and not by selling music. I did a separate video kind of reacting to the CEO of Suno and an interview he had done, and I was just so offended as, an artist, as a creator myself, and he just sounded so tone deaf. To his credit, he goes, I think, musicians and artists and stuff like that are like lazy. I don't think that they like making music. It's too hard. I definitely don't agree with that. But then on the flip side, I go, well, you guys have created a platform that can make available an experience that maybe wouldn't be possible for certain people. So, to the article's point, you are providing a subscription-based service on making music, but not necessarily selling music, because these aren't necessarily going to be, artists that are going to put their music on music platforms. But this is a music business channel. I am a creator, and I'm very much interested in ensuring that the stuff that we do, the legacies that we are trying to build, can be protected. And it kind of scares me that this idea that a company, if all of these courts do end up coming back and they go, no, it is fair use. So that means that any AI company could just waltz on in, take my music catalog that is valuable to me, for sure, train its AI and start spitting out dark pop music, and I can't say anything about that? How's that right? Drop a comment down below. I'm top music attorney, Miss Krystle.